As a general matter, public policy in the United States encourages the arbitration of labor disputes and collective bargaining. But what if an arbitration clause in a collective bargaining agreement, or CBA, exempts strictly management functions? Does this mean that the arbitration clause exempts disputes over contracting out work because contracting out work is a management function? The United States Supreme Court considered this question in United Steelworkers of America versus Warrior and Gulf Navigation Company. Warrior and Gulf Navigation Company was a marine transportation company that transported steel and steel products by barge. Employees were covered by a CBA and represented by the United Steelworkers of America Union, or USW. In the mid to late 1950s, Warrior outsourced maintenance work of its barges to other companies and laid off some of its employees. The companies then used Warrior's supervisors to plan out the work, and the supervisors hired some of the laid-off workers at reduced wages. At the time, the CBA had a grievance provision that required employees to submit disputes over the meaning and application of the agreement's provisions, in addition to any local trouble, to arbitration. But the grievance provision explicitly excluded matters that were strictly a function of management from arbitration. Further, the USW tried for many years to include a provision in the CBA that would prohibit Warrior from contracting out work, but it was rejected. Subsequently, USW filed a grievance against Warrior for contracting out the work. After the parties couldn't agree to a settlement, USW sued Warrior in federal district court to compel arbitration. In response, Warrior moved to dismiss the complaint, arguing that contracting out work was strictly a function of management and not arbitrable under the CBA. The district court agreed and granted Warrior's motion to dismiss. USW appealed to the Fifth Circuit Court of Appeals, which affirmed. The United States Supreme Court granted cert.